First District Court of Appeals is now in session. All who have business before this court, draw near, give attention, and shall be heard. May God save these United States, great state of Florida, and this honorable court.
Please be seated. We have one case scheduled for oral argument this afternoon, the case of International Bonded Couriers Incorporated versus Florida Department of Revenue. Counsel ready to proceed. Counsel, we have allocated 20 minutes per side for this oral argument. Would you like to reserve some time for rebuttal?
Yes, I'd like to reserve 7 minutes for rebuttal.
So noted, Madam Clerk. You may continue, Counsel.
May it please the Court, my name is Jeanette Maffa, and I'm here on behalf of International Bonded Couriers. The final order should be overturned, and IBC's unadopted rule challenge remanded back to DOA for a determination of whether the zip code program is an unadopted rule. This case is not moot, and IBC remains entitled to relief from this illegal program. DOR has no authority to select the winners and losers of export in Florida.
Well, let's start right there. What is the alleged zip code program that is being challenged?
The zip code program being challenged is defined in page 3 of the initial brief, and essentially is a collection of policies the department invented to interfere with freight forwarding in Florida and resolve a tax implementation problem.
But these were 3 separate actions by the department over time, were they not?
In the original petition, under Chapter 120.56, a description of the policy is required, and a description was provided at the time with all the information available. Because it was a secret program, we didn't have the managed compliance agreements until this court actually provided them on an interlocutory appeal.
And you don't dispute that these collective statements that you refer to the zip code as the zip code program are not in effect now, and certainly by virtue of action by the Florida legislature?
I believe they're in effect because they haven't been repealed.
Okay. Let me ask it a different way. Are the policies being, are any competitors or vendors using that quote zip code program as opposed to the legislative authorization to obtain 0% policies or taxation?
Are you referring to the certificate program when you say the legislative?
Okay, so let's take, yes, the legislative program. Mm-hmm. Okay, these 3 challenge programs that you call the zip code program, are they being used by the department or by any competitor?
I would say that because they haven't been repealed, they're still valid, and it's still an open program. But whether or not any particular policy is in use at any given time is not the full picture. Essentially, this is like a weapon. It's something the department had no authority to create or to possess.
And I think we're past it. The legislature has enacted a law that tells the department exactly how they're supposed to administer this type of program. Is that right?
No, the certificate program is entirely different from the zip code program. So the certificate program that's been enacted exempts particular transactions. It does not automate the resolution that the zip code program provided. So the problem is that when an item is purchased online from a retailer and sent to a Florida exporter, they're being taxed because the online retailer doesn't know that the ship-to destination is not the final destination. So there's this industry problem. It's a national problem, and Florida tried to resolve it through the zip code program. The certificate program has no automation whatsoever. Essentially, what you receive when you apply is a certificate that can exempt transactions, and you can ask online retailers like Amazon or Walmart.com if they'll accept it, but they're under absolutely no obligation to accept it.
Sure, but certainly the ultimate goal, right, for that certificate program is the same as the zip code program, and that's to eliminate the number of refund applications being processed by the department and submitted by competitors like your client.
It can reduce it if they're accepted by retailers, but again, this is not automated, and it's that automated resolution that was really the benefit of the zip code program. Most of the people who are engaging in these transactions are not located within the United States, so that refund process was not very accessible to them. This automated process through the zip code program really resolved it permanently for the beneficiaries of the program, and that program could have been adopted. It could have been enacted by statute as well, but the department passed on those opportunities and instead proposed a program that coexisted at the same exact time as the zip code program as almost a second-tier benefit for every other freight forwarder. So for at least 5 months, as admitted to by the department, the zip code program and certificate program coexisted.
Sure. So why did you proceed only under 120.56? Weren't there other avenues for relief under 120 for your client?
I don't believe so. I think 120.56 is the appropriate avenue. This was a policy that the department invented and had no statutory authority.
Let me ask it differently. I didn't ask if it was most appropriate. Was it the only path under 120 to provide any relief to your client if they felt that their substantial interests were affected by the department's policy?
Yes, I believe so.
It was the only one. Okay.
Is it a given that at the time of the final hearing that the department had abandoned or ended use of these programs at issue?
The department had submitted an affidavit from an employee, signed by an employee who had no involvement in the zip code program, stating that the 0% rates were not presently in effect. There were no future promises made by that affidavit. So at the time of the hearing, no formal repeal had occurred. And I think Florida law is pretty clear that a repeal is required. The case law cited, including the DOA cases and the Sheridan case out of this court, all include instances where either a statutory or rule was enacted to repeal the unadopted rule, such that there's no fear that this will come back and that the agency has the ability to reassess this at any time. In fact, that already happened in this case once. In February of 2020, the department did go forward revoking the policies. That was when IBC initially served their petition, and letters went out to the beneficiaries of the program saying, you know, the program's canceled, essentially we're done with it. But sure enough, in secret, months later, DOR reinstated the program, and by August 2020, every single beneficiary of the program had all of their benefits back.
How long had these programs been in effect prior to the final hearing?
I'm sorry, can you repeat?
How long had the programs at issue been in effect prior to the final hearing?
Prior to the final hearing, since all the way back to 2011, the department claimed that they were approached by someone that had, I think, the language was something to the effect of a unique business model, and I'm not sure how export would be in a unique business model here in Florida, but this company was able to convince the department to initiate this program, and then 3 other businesses were able to benefit. So for over a decade, these businesses in this, as the CEO of IBC described it, special club, were able to really just dominate the industry here in Florida and nationally as well. And every state that has a sales tax has this tax implementation problem. So to give
when was the last time the zip code policy was applied based on the record before you? I understand you say the rule or unadopted rule is still in effect, but when was the last time it was actually applied? What year?
Which aspect of it?
Well, you call it the zip code program collectively, so you choose any of them.
Any of the policies? I think there's no way to know. The department stated that they've removed the 0% rates, and those are not visible any longer.
Right.
But
So when did that happen?
The 0% rates, I think, were around the time of the affidavit, and so it would have been it was May 17th, 2022, because that was when they issued their letters for the second time revoking the program. In April, it took them about a month to actually remove the 0% rates. But again, they did this in February 2020 when IBC initially served their petition. These 0% rates were revoked, only for DOR to secretly reinstate them again. So IBC had to go through years of litigation just to get the same sort of revocation letter sent out.
Well, to follow up on Judge Rowe's question, could you have proceeded under 12065?
I don't believe that would have been the appropriate avenue in this case. I think this is clearly an unadopted rule. I mean, this is a policy that was created with there's no statutory authority for it, and it, again, disrupted the entire industry in the state. And I think this was the unadopted rule was the proper remedy for it.
Well, I'm going to take one more shot at this question because I hear appropriate, I hear proper. But doesn't 120 also provide a remedy for persons whose interests are substantially affected by an executive agency's action?
Yes, I suppose it could. However, again, I just believe the unadopted rule was the appropriate remedy here.
So you put all of your eggs in that basket?
Yes.
Okay.
In the unadopted rule.
You've asked for essentially a final order. The Shands case that we issued a couple of years back, we went ahead and made the declaration or provided a final order. Are you asserting that we have to remand this back to the ALJ, or do we have jurisdiction and authority to go ahead and issue or write a final order that you're requesting?
I think that you could do either. I think the preferred path would probably be to remand to DOA so a determination can be made. The ALJ actually asked that if the final order was to be overturned, there were some additional findings of fact that he was interested in looking into. Ultimately, I believe this case should be remanded back to DOA for that finding. The first several pages of the final order describe a very complicated program the department enacted, and instead of having it be repealed, the final order describes it as being, quote, sort of repealed. IBC was entitled to more than that. They were entitled to a permanent revocation of this program.
Well, what facts remain other than potentially entitlement or to fees? What facts remain that the ALJ would need to address in order to provide a final order?
Well, I mean,
essentially, his order to me reads as if it's a final order, but then says I'm not issuing one based on mootness period and I'm out. But what other additional facts would need to be fleshed out?
Well, I'm not sure specifically what he meant when he said that he would want to essentially have the case back to analyze additional facts there, but he relied on the City of Chicago case that has a standard of voluntary secession plus deference, and that's just not the standard in Florida. And I think that's why he said there was no repeal, there was a sort of repeal, and relying instead on this voluntary secession plus deference.
Well, City of Chicago, interestingly, I looked, and we've had 2 citations of that case by the 11th Circuit, but in my opinion, the ALJ stretched that case a bit too far, and the 11th Circuit narrowly applied it just to say that there is some deference. If it's a governmental authority, then there can, if there's a voluntary fix of the situation, but none of those cases addressed the issue of whether a mootness exception applied, i.e. legal consequences.
Yes, and
so is this is separate and apart or different, distinguishable from City of Chicago?
Well, here it is. I think the biggest reason is that deference is in violation of Article 5, Section 21 of Florida's Constitution, and I think that deference plays in several levels in the final order. So that standard.
Can you describe the deference that you're? I mean, I saw that in your brief, and I didn't quite follow what you mean. The ALJ was not deferring to any interpretation by the department when it concluded that the voluntary cessation doctrine applied. Who was the ALJ deferring to?
Well, I believe that there's a couple levels to this. So on a more general level, I do think the ALJ was providing deference to the government's this presumption of good faith. And I do think there's government deference in that alone.
But that's not what the constitutional provision discusses. It discusses, it's more the department's legal interpretation. It's not, a factual determination of whether there's good faith or not.
Well, there's also that as well, and I think it comes up in 2 ways. So DOR takes the position that the certificate program revokes the zip code program, and that actually would have been an excellent opportunity to revoke the zip code program. Language could have been brought into that or through rulemaking that said this is the only way going forward. So the certificate program is the only means, and the zip code program is terminated. And they passed on that.
Let me ask a question on that one. So are you saying that the legislature cannot, by organic law, revoke authority for an agency to do something, and that the agency then has to adopt a rule saying, yes, the legislature revoked our authority, we can't do this anymore? I mean, there can't be legislative revocation?
Yes, I think if the agency was not able to reassess the issue going forward and was not able to bring back the zip code program, then the legislation would have repealed it effectively. Here, it just created some new program that provided a slightly different benefit while leaving the original program, the zip code program, intact such that they could coexist together. But sort of going back to your question on deference, there's also the deference to DOR's interpretation of that certificate program. They've said before that that certificate program prevents them or precludes them from moving forward with the zip code program, but there's no language in there whatsoever that addresses the zip code program. So I think there's a deference to their interpretation of the certificate program as well. and also a deference to their interpretation of what constitutes a repeal in this scenario. I think getting having an affidavit from one employee who was never involved in the zip code program, promising that in that moment there's no zip code program in effect or no 0% rate in effect, is simply not sufficient relief for a repeal. And again, the repeal that was provided, or as the ALJ described it, a sort of repeal, was already done in February 2020, years before.
If it's our position that we agree with the ALJ that the issue is moot, what's your best argument on applicable exception?
So there are 3 exceptions to mootness, and I think all 3 of them apply. I think the best one is the likelihood of reoccurrence, so I'll start with that one and then briefly touch on the others. In terms of likelihood of reoccurrence, it's not just a likelihood, there's a history of that here. IBC has already been through reoccurrence. They served their petition in February. They only needed to give 30 days. They gave months and months believing DOR was really going to terminate this program, for DOR to only terminate it and then go back and reinstate it in secret all over again. So this has happened before. There's a history of it. It's going to happen again. And the reason it will happen again as well is that the industry problem remains. I mentioned previously some of the differences between the certificate program and the zip code program. The zip code program automated a resolution to this problem. It was really a novel idea and permanently fixed an issue that's plagued this industry since the rise of online retailers.
So your real complaint is that you wanted the zip code program. The department is not going to do it anymore, and now you want us to order the ALJ to find to order them to revoke it. It seems inconsistent with what you're saying. You're saying it's a good program, but you want to challenge it as an unadopted rule.
Yeah, I think the zip code program could have been a great program if only it had been available to everybody. This was a zip code program created to benefit only a select small group of businesses. Those businesses had an advantage for the last decade plus over every other freight forwarder, not only in Florida, but in every state in the country with a sales tax. This was a major benefit, and it should have been adopted as a rule, and it could have been available to everybody. But without that, there's the certificate program.
You're well into your rebuttal time, by the way.
Yes. If there's any other questions, I'll reserve the...
Judge.
Yeah, I was going to ask you to hit the legal consequences exception.
Yes, I'll wrap that up. So to summarize, I think the best argument is the likelihood of reoccurrence, and I think the 2 reasons for that is that there's a history of reoccurrence. IBC already went through this in 2020 just to have the program secretly reinstated again, and then also the industry problem remains, and at some point in the future will need to be resolved in some manner. These transactions are taxed on a daily basis, and it's again an industry problem nationally. There is a high likelihood of reoccurrence, but also this is an issue of great public importance.
Hit the legal consequences.
The legal consequences here, so the fees in this case are not speculative. They're mandatory in cases of an unadopted rule. I mentioned 120.595 in the initial brief, and that was amended in 2008 specifically to avoid the scenario where an agency can change their mind at the last minute or late into litigation after a lot of fees have been incurred. In that change in 2008, 30 days was provided from the time you serve the petition to when you file it. That gives the agency some time to initiate rulemaking. But after that point, after that initial 30 days when it's filed, the petitioner is entitled to fees up to the point that the agency initiates rulemaking. Here, to this day, DOR has not initiated rulemaking with the zip code program. They've simply retained their authority to return to this at any time, and therefore it's not been repealed.
Counsel, you may have hit on this already, but then again, was there any evidence or record of a threat of a recurring violation by the department?
Of a reoccurring violation of the
Alleged
zip code?
misconduct, so to speak.
I think there's absolutely a threat of a reoccurrence here because, again, the industry problem remains. This is a very big problem in this industry nationally in every state with a sales tax. And so the problem that the zip code...
Specifically to the department, not the industry.
Specifically to the department?
Yes.
Well, they're dealing with as well. Every single transaction qualifies for a refund. There's an administrative burden there. So they're also motivated, I believe, to resolve the industry problem. So there's the industry problem, and then also the history of reoccurrence has shown that the department's willing to put this on the back burner when challenged and then reinstate it when in secret down the road. And I'll save the rest for rebuttal unless there's any other questions.
Thank you, Counsel.
Good
Good afternoon. May it please the Court. My name is Jacek Stramski, along with Chief Assistant Attorney General Tim Dennis. I'm here for the Department of Revenue. Your Honors, this case is in many ways like Frankenstein's creature. It was largely not alive when it came into existence. And now, despite being brought along with switched out parts, changing arguments, and phantom facts, no part of it remains alive. The Department requests that the Court affirm the final order finding this case to be moot. I want to touch on a couple of issues that you raised, Judge Thomas, regarding what would have to happen below for there to be a finding that there was an unadopted rule. First of all, there is no conclusion that the Department's actions do rise to the definition of a statement that constitutes a rule that could be challenged under 12056. There are a number of hurdles that IBC would have to get to obtain such a ruling on the merits. Perhaps the first and most obvious one is that Section 202.22 2B2, this is an issue that was not raised because we were the prevailing party below. But that statutory section explicitly excludes the database within which these rates were listed from the definition of a rule. And so the Department's position has always been that the Department's past practices in terms of listing these 0% rates that were applicable only to addresses that were used exclusively for export and for which statutes provided that no sales tax would be applied to transactions going through those addresses, that the Department's use of the database by statute doesn't fit the definition of a rule.
Well, if you could, I'd like you to hit a little bit. Counsel has argued about deference to the ALJ's finding that there was good faith for the Department. And so let's talk about that a little bit. What was the Department's purpose in, taking these three actions that are collectively discussed as the zip code program over time? What was the purpose, and why did the Department change its practice, those three times, and then what happened with the legislative enactment?
There were four forwarding agents that had 0% rates listed in the Department's address and jurisdiction database. When the Department was first approached in 2011, it's true the Department thought this was a unique business model whereby a freight forwarder would be receiving property purchased in Florida for export outside of the country. By statute, by 212.065 subsection A, such purchases are excluded from sales and use tax when they are irrevocably committed to the exportation program. So the understanding of the Department was that this first freight forwarder that approached the Department had an address that was used exclusively for export, and by statute, any transaction, any item that was shipped to that address would be not subject to sales tax.
And let me pause just there. So is there a benefit to the state in that particular practice of publishing 0% for that, and for the taxpayers as well?
Well, I think the benefit was anticipated but probably speculative. The expectation was that perhaps retailers could go to the database and identify that a 0% rate would be applied to items for export. It's not clear, and there's no evidence that that ever happened. None was presented below. But there were other ways that individuals and freight forwarders could secure this exclusion from tax. This is not a new exclusion. This was not created by the listings of the 0% rates. By rule, in Rule 12A-1.0015, even before the recent legislative changes in 2021, any sale of property that took place and that was by its terms delivered from the dealer to a carrier, licensed customs broker, or a forwarding agent for final and certain movement outside of the state was automatically excluded from sales tax. So that exclusion from sales tax already existed, and there were ways for it to be realized. Whether or not these listings facilitated that or not, we don't know. There was no competent substantial evidence of any kind in the record to show that anybody was able to benefit from it. What's more, there's no competent substantial evidence in the record that any individual under the Department's past practices was required to pay sales and use tax where it wasn't due, that was able to obtain the sales tax exclusion where otherwise that wouldn't be available. There was no showing that any of IBC's customers, frankly, were forced to pay a sales tax on exports that were shipped through IBC that otherwise were excluded by statute.
Okay, so let's pause there. So that's the first program, and there's a suggestion that DOR is pulling that back and then secretly publishing a second one. Why was the second one enacted?
Well, there was no secret, first of all, when the department did want to remove these rates initially in 2020, and we were threatened with litigation, frankly. So we were under agreements with 4 freight forwarders, and we did reinstate those rates. It wasn't a secret. We let council know that those rates were being reinstated. And again, I'm not sure how a program can be simultaneously secret and publicly available to all retailers. That really doesn't make any sense. But that was really the reason for it.
All right, and then there was another change, I believe, because of the United States Post Office, the 9-digit zip codes versus 5. Can you talk about that a little bit?
That was really the reason why the department was not able to accept additional applicants to have these 0% rate listings. The department's address and jurisdiction database was never intended to identify individual exempt entities from sales and use tax. It was always meant to identify the situs of an address for communications and services tax. It's limited in its search functions, which is in the record, was testified to, and anybody can look it up, that the search function is limited to a 5-digit zip code number. The reason why the 5-digit zip code, unique 5-digit zip code was critical was to be able to separate out a freight forwarding address, say if it was located at the same street address as other businesses that might have suite numbers in that same location. A unique 5-digit zip code was necessary for that purpose. There is no way to search by a 5 plus 4 digit.
Regardless of the program you were under, it wasn't applied evenly or consistently. You still had 4 vendors who got it and other vendors who applied but didn't.
Absolutely. And that was one of the reasons why the department wanted to move away under the threat of litigation. We reinstated those vendors who had agreements with the department. We still don't believe that the challenge properly here would have been an unadopted rule challenge because this database is excluded from rulemaking. There could have been other challenges that any challenger could have brought, whether through circuit court litigation when administrative remedies are not available. That can happen. Your Honor mentioned substantial interest proceedings under Chapter 12057. That possibly could have been another vehicle.
Was that ever pursued by any of the competitors in this case?
They were not, no. And I think it's important to note here that IBC never, by its own admission, sought this listing by its own admission. It, in the words of the CEO, decided to pursue the legal route when it was exploring the ins and outs of the listings from its competitors. IBC's CEO mentioned that he was just doing that in order to get information from his enemies or keep his enemies close. So there's no agency action here. Turning to 12056, there's no agency action here that's been challenged. And going back to very quickly, what is necessary in a determination for an unadopted rule? We mentioned that this case would not be subject to challenge because of 202.22 2B2. The department also mentioned that it would not be practicable or feasible to adopt rules implementing either alleged policies 1, alleged policy 2, or alleged policy 3 as they were identified in the petition because the statutory change is an indication that the legislature has meant to occupy the field. The legislature has provided a very comprehensive mechanism by which the department can receive applications from freight forwarders, whereby those freight forwarders identify addresses being used exclusively for export, where the department can verify that information, issue a certificate, publish that information publicly, and now by statute, expressly retailers and dealers are specifically permitted to not charge sales and use tax when, by the terms of a transaction, items are supposed to be shipped to that certified.
Well, it sounds like appellant's not satisfied with that, that seems, there still seems to be a quote industry problem here. But moving on from that, when does the record say any of these 3 policies collectively referred to as the zip code program, when was the last time one was in effect?
Respectfully, I'm not exactly sure what appellant means by the zip code program that seems to be changing. With respect to the alleged policies 1 and 2, as alleged in the petition, those were not in effect more than 1 year before the petition was even filed below.
So what year was that?
At the end of 2018.
2018?
Yes.
Okay.
Now, there were rates that remained for the 4 entities that were listed in the database, and those were removed in May of 2022. After the legislature created this comprehensive scheme to identify certified addresses, it did take some time for the department to implement that. There's no doubt about it. I don't think that's any indication that, if the statute becomes effective, that it's not implemented immediately. The department views that it can operate both, maintain both positions. The department has been unequivocal here that the new legislative scheme precludes the department from revisiting or re-implementing anything like the challenged alleged policies 1, alleged policies 2, or alleged policy 3. The department made this clear in its representations to third parties when it revoked and removed the listings. It made that clear in testimony under oath at the final hearing. It wasn't just an affidavit. The department's deputy general counsel actually testified to that effect.
Well, and I think it's clear the ALJ accepted that, but he was very, I think, set on declaring this a Pyrrhic victory for appellant. Respond to that, because you earlier made a statement that you're the prevailing party. So kind of compare and contrast this prevailing party issue and the ALJ declaring the appellant to actually, have achieved a Pyrrhic victory. And then if you'll address in that vein the legal consequences exception to mootness.
Well, we didn't prevail on the merits, right? That is clear. This case was moot. It was undeniably moot. I think the competent substantial evidence on that question is overwhelming. And with respect to exceptions to mootness, I think there's an initial hurdle that IBC here cannot clear, which is it failed to preserve any argument below that any exception to mootness applies. IBC did not make any argument regarding exceptions to mootness, either in its pre-hearing submission to the ALJ at the final hearing or in its proposed final order after the hearing.
Okay, and so let's pause there. Assuming a party, here the department, has established the facts necessary to demonstrate that its action, that there's mootness as to the controversy before the ALJ, who has the burden of demonstrating an exception?
I believe the rule is that the burden on demonstrating an exception would be the same as whenever an entity makes an affirmative representation, and so that would be the person claiming that an exception would apply. But regardless of who the burden is on here, the question of mootness was very clear below, and it was never raised. Now, it was never raised at the trial proceedings. And as the Florida Supreme Court has specifically instructed, to be preserved for appeal, the specific legal ground upon which a claim is based must be raised at trial, and a claim different than that will not be considered on appeal.
And so just to be clear, it's your position that before the ALJ, the appellant made none of the arguments regarding the exceptions to mootness that are recognized under Florida law?
Yes, but more specifically, there was one reference to these challenge statements being capable of repetition in the proposed final order, I think at paragraph 68. That was a conclusory statement. It wasn't sufficient in our view to preserve an appellate issue. But the collateral legal consequences doctrine certainly was never mentioned then, nor was the great public importance issue. IBC claims that it raised objections to mootness in response to the motion to dismiss that was heard without a hearing and under the assumption that all the facts taken in the petition were true. Even there, IBC made no reference to the collateral legal consequences doctrine. It did reference capable of repetition and great public importance exceptions in response to the motion to dismiss. But as the Supreme Court has instructed, that's not sufficient because on the motion to dismiss, there are no facts that are being presented. All the facts that are being presented, all the facts alleged in the petition are taken as true. It was incumbent on IBC in order to preserve any argument regarding any exception to mootness to make those arguments in the context of all the evidence that was presented to the ALJ at the close of evidence.
To the extent that this court would recognize the voluntary cessation exception that the ALJ applied here, was it your burden to show good faith, or was it the appellant's burden to show bad faith?
We would argue,
and again, and advocating for an exception to apply.
Yes, Your Honor. We would argue that it would be the appellant's burden to demonstrate bad faith. But frankly, in this case, I don't think that really matters. The ALJ did mention that he was not imputing bad faith on the part of the department. The ALJ also made other statements. The ALJ mentioned that it was the department's burden to demonstrate its good faith. The ALJ stated very clearly that the burden was heavy and that the department met it. So regardless of which way the burden falls, or even if there's no presumption of good faith, which courts have recognized with respect to governmental parties and other proceedings, if in the context of mootness, if there is no presumption of good faith, here in any event, the department would have met a heavy burden to demonstrate its good faith in removing these statements and making clear that the department simply cannot return to them. We're happy to make that representation again, given the comprehensive legislative scheme that was enacted. I did want to mention, though, on the merits, some of the exceptions to the mootness doctrine, since there certainly is interest on those. This case does not present an issue of great public importance. It does not present an issue of any importance at all. The challenge statements do not apply to anyone, and there's no realistic chance that they ever will. Similarly, the capable of repetition exception, I think, is completely foreclosed by the ALJ's findings of fact based on the competent substantial evidence that there is no reasonable likelihood that the department will ever return to those challenge statements absent a change in the law. And I want to address the removal of the rates in 2020. If anything, that shows that the department, even back then, was eager to remove those rates from the database because of the implementation problems. Now, it was the threat of litigation that essentially forced the department to return to that position. But once there was a legislative fix, the department implemented it. The department thinks that this fix works well. There's no difference in terms of automation between the
Regarding
database.
that point, Counsel, has IBC been given a certificate under the new program
Yes.
alongside its competitors?
Yes, Your Honor. IBC is a participant and has been since 2022, soon after the program was initiated, and it stands on the exactly same level playing field as anybody else that has a certificate. Retailers who ship to IBC's certified address do not have to charge sales tax by law.
And I'd like to go back to the exception on adverse consequences, and here that I think the only adverse collateral consequence here, we're talking about our fees and costs. And that goes back to the questions I was asking on other paths that were available under 120. Would you concede that there would have been a viable path for competitors excluded from the so-called zip code program to challenge the department under the substantially affected interests provision of 120?
If a party requested some sort of relief or an action from the department and the department denied it, I think that could be taken as a determination of substantial interest if an applicant would raise that as a basis for relief. And there may have been, again, I think circuit court relief if the claim is that the department was acting outside of its statutory authority. There certainly is relief when there are no administrative remedies provided.
Right, and I think that's, the ALJ certainly discussed kind of the Pyrrhic victory, kind of the length of this litigation. It's been protracted, certainly, no doubt. But at the end of the day, if we're looking at this kind of these adverse consequences flowing from, or the exception to the mootness doctrine, don't we also have to consider if a party puts all of their, again, I'll use the same metaphor, eggs in one basket, can they then say, well, look, we should get fees because this particular challenge, didn't bear any fruit?
I think this court and DOA have for decades been very consistent that to get fees for an unadopted rule challenge, there has to be a determination on the merits. And for a determination to be made on the merits, the case has to present a live controversy. With respect to collateral legal consequences and whether or not a claim for fees is such a collateral legal consequence, I think that's not necessarily consistent with this court's history in Lund, where the court considered specifically on appeal a situation where the agency reversed and rejected, apparently, findings of fact below.
Well, and Lund distinguishable, because that was under 595.5, the appellate standard. Our court in Chan distinguished Lund in a footnote 4, and said that's two different provisions. If you look at 5952, for example, that's discretionary. Lund was under a different provision.
Your Honor, the court in Lund identified that there were actually two avenues for attorney's fees under 125.95.5. One was discretionary if the agency's action was a gross abuse of discretion in precipitating the appeal. The other was mandatory if the agency improperly rejected findings of fact. And Lund court expressly mentioned that either one of those prongs would not be sufficient and would be not sufficient to sustain collateral legal consequences. I think the concern in terms of attorney's fees is where a party below is facing an award of fees against it, and on appeal, the issue becomes moot. Then there's actually a negative consequence that that party's facing, and the purported beneficiary of that attorney's fees award cannot use mootness as both a shield and a sword to preserve its claim. But I would mention there are additional distinctions between Lund and both Shands, where in those cases the merits of the case were squarely before this court. And so if this court ruled one way or the other, that could directly impact whether or not those fees would be granted. This is not that case here. The merits are not before this court. There would have to be substantial additional proceedings below, again, first of all, to find whether or not the challenge statements of rule. I see my time is out.
Let me finish your statement.
Excuse me?
Have you finished your statement?
Well, Your Honor, we believe that the competent substantial evidence clearly shows that mootness applies in this case. Appellant has not preserved its arguments that any exceptions to mootness apply, but in any event, we don't believe any of those apply.
Thank you, counsel.
Thank you.
Counsel, I believe I understand your arguments regarding the exception to mootness. In that regard, though, the ALJ made this statement in final order, that the policies about which the IBC complained are as good as gone, with no realistic chance of reappearing. If we will just, believe you in terms of your arguments that you've made in terms of your briefs and on appeal, what evidence was offered in the proceedings below the conflict with that statement on mootness and the exceptions to mootness?
In terms of likelihood of reoccurrence as the exception to mootness, I think it would be that there's a history of this. It was mentioned twice that the February 2020 letters were sent because of a fear of litigation from the beneficiaries of the program. That is not true, because those contracts were valid for 1 year, and they were renewed every year that this litigation went on. So if the concern was that they were going to be in breach of contract by revoking them in February 2020, they could have just let them expire, and they would have expired long before hearing. Instead, they were renewing them actively during litigation. So there, again, in the past, when they're feeder to the fire, so to say, the program suddenly disappears. But that authority to instate a program like this, to engage in secret contracts, to provide benefits, that authority has not been surrendered in any way, and there's been no repeal of that. So I think the history, and then combined with the fact that this industry problem still remains, their certificate program, now that it's been enacted, it provides a level playing field, but it does not resolve the problem whatsoever that the zip code program resolved, that automation of a resolution to tax implementation. There's never been a question of taxability in this case. It's tax implementation only.
Can you address, did that answer your question? Can you address the preservation issue on the mootness exceptions?
Yes. On the third motion to dismiss, this issue was addressed by both parties, including the exceptions, and they were raised, and the ALJ actually ruled in favor of IBC, that the case was not moot whatsoever, only to change directions on the final order. So all of this was argued below and was properly preserved. And Judge Thomas, you mentioned previously the Pyrrhic victory. I just wanted to add that Pyrrhic victories are expressly forbidden by the mandatory attorney's fees and unadopted rule challenges. If there is an unadopted rule here, which I think is very clear from the first several pages of the order that detail the many specific policies in place, then IBC is entitled to those fees. Ultimately, Your Honors, what occurred in this case is...
Counsel, your time has expired. I'll allow you to wrap up.
Oh, sorry. I'll just conclude quickly. Your Honors, ultimately what occurred in this case is wrong. Sections 120.56 and 120.595 provide protection to those substantially affected by agencies acting outside the scope of their authority. They do not provide protection for agencies to continue their illegal policies while avoiding statutory attorney's fees. At a minimum, all three exceptions to mootness apply here, although only one is required. Therefore, I would respectfully ask this Court to overturn the final order and remand the case back to DOA for a determination of whether the zip code program is an unadopted rule. Thank you.
And thank you, counsels, for your respectful oral arguments this afternoon. This concludes our oral arguments for this afternoon. We are adjourned.
All rise.